This is the second lecture in Common Law 2. We're going to start today on the quasi-suspect classifications, starting off with gender. The court has explicitly held that government bears the burden of proof in gender discrimination cases, and that an exceedingly, and this is a quote, persuasive justification is required in order to show that gender discrimination is substantially related to an important government interest. Again, it's a semi-suspect class. It's not necessarily a fundamental right, and you have to keep that in mind. And when we talk about gender, it's semi-suspect. Reason why it's semi-suspect, because of those two reasons. So when we look at cases like Gildig versus Aiello, here we have California's disability insurance system excluding disabilities resulting from normal pregnancies and birth. Okay. So women with pregnancy-related disabilities challenge the exclusion as violating the Equal Protection Clause. And so the issue becomes is, does a state disability insurance system exclusion of pregnancy-related disabilities violate the Equal Protection Clause? And the court says no. And the court says no because not every disabling condition is covered under the program. And the program is intended to function like regular insurance. So that being the case, the program's purpose is not one that is treating all, it's not concerned with equal protection, it's concerned with providing protections. And that's a major difference. That being the case, the court decides that no, it's not covered and that it has nothing to do with discriminatory behavior on the part of the state. There's no intention in doing that. It just basically is nothing more than an extended insurance policy. Move on to other classifications. All the classifications that are reviewed that don't fall into one of the previously discussed categories are reviewed under the rational basis, and keep in mind here that standard is upheld unless there's no rational relationship to any conceivable legitimate government interest. Nevertheless, if the government has no interest in denying a benefit for imposing a burden on a group of persons other than a societal fear for dislike of them, the classification will not meet the standard. So in Claiborne, City of Claiborne, Texas versus Claiborne Living Center, basically the fundamental facts of Claiborne Living Center contended that laws impacting the mentally retarded should be given heightened constitutional scrutiny. Okay, impacting, which is interesting, right? Not negatively or positively, but impacting. So the issues are laws impacting the mentally retarded to be given heightened constitutional scrutiny, and the court says no, that laws impacting the mentally retarded are not to be given heightened judicial scrutiny. Several factors support this conclusion. First, the great variation in treatment required for mentally retarded persons argues against divesting legislatures of authority in this area in order to vest greater oversight in the judiciary. In other words, it's a complicated area dealing with all kinds of issues, and that you can't really leave it up to the judiciary to handle those issues in any real ongoing manner. So that's an example of where the rational basis test is clearly put into play and makes very clear that the government has to have that interest. Another case is Romer versus Evans, and here several municipalities passed ordinances banning discrimination in housing, employment, etc., based on sexual orientation. So now we think we're getting closer to something that may be more of a protected class, but falls into the other classifications. All right, in response, the state voters adopted a state constitutional amendment prohibiting any state or local action protecting the status of persons based on their homosexual or bisexual orientation. So the court holds that a state constitutional provision that identifies persons by a single trait and then denies them the right to seek any specific protections from the law, no matter how local or widespread the injury, is so unprecedented as to imply animosity towards such persons and is thus not related to any legitimate state interest. So here, what we have is a clear example of the state overstepping its bounds. Again, with rational basis, the state has got to just show some reasonable rationale for doing what they're doing, and in this case, it's not substantiated. So the issue are laws impacting those with sexual preference based on sexual preferences, is specifically problematic. Okay, so issues. Does Colorado's Amendment 2 violate the Equal Protection Clause because it singles out a class of citizens, homosexuals, for disfavored legal status? Okay, violate the Equal Protection Clause. In this case, it's yes. And why? Colorado's Amendment 2 violates the Equal Protection Clause because it singles out a class of citizens, homosexuals, for disfavored legal status. The Colorado Supreme Court construction of Amendment 2 found that its objective was to repel existing anti-discrimination ordinances. Thus, Amendment 2 is far-reaching in that it places homosexuals in a solitary class without legal protection against discrimination. So separating those based on that preference becomes problematic in the Romer case. All right, wealth is not a suspect class, as we've talked about before. So basically, there's no fundamental right to require wealth to be distributed in a certain way in terms of equal protection anyway. So typically, wealth is not a subclass, or it's not a group for anything, because anyone has access to it. The belief fundamentally is that anyone can acquire it, and so it is not a clearly suspect class. What about age? Age is not a suspect class. In the case Massachusetts Board of Retirement versus Murgia, right? Police officers can be forced to retire at age 50, even though he's physically fit as a younger officer. You got Gregory versus Ashcroft in 1991, a state constitution that requires state judges to retire at age 70 does not violate the Equal Protection Clause. Age is not protected because people are different at different ages, and there's a rationale for limiting the age at which someone can perform a function, because it's not specific. It's not like everyone reaches a certain age and they can no longer perform that particular function. And as a consequence, it is not. Wealth is not as well. Abortions, which is another contentious issue. Supreme Court upheld the government refusal to pay for abortions. This is a great political sort of a bone, and at the end of the day, there is no legal requirement for the government to actually pay for or support in that way a constitutional right to obtain an abortion. Education, we talked about this before. Supreme Court, as a suspect class, has not said that this is a fundamental right. Okay, so now let's just talk about fundamental rights, so we're very clear on exactly what those constitute. Fundamental rights are protected under the Constitution. They're fundamental, which means they're fundamental, as I said in the last lecture, to the functioning of a free society. You can't take them away and say that you've got a republic or a democracy. So there are some things that are so essential to that fundamental processing of rights and the fundamental well-being of the country that you can't get away from them. So, for example, the right of privacy. It's not listed anywhere in the Constitution. There is no spelled out, fundamental right to privacy. But if you take this idea and you move it forward, if you don't have a right to privacy, which falls underneath this, we call it this penumbra of rights, then you really don't have a free society because you can't express yourself. If you can't express yourself, then what good is living in a democracy or a free society? So what about marriage? Now, marriage has been something that we've visited in the last several years, and although the political structures, in the country initially decided that they had to defend marriage against those that were not a heterosexual couple from marrying, that's changed. It's changed because the society has changed and because it has been considered a fundamental right. Now, when they examine, these cases, they're looking for that particular element or two that rides in the face of this right to privacy. So let's talk about marriage, right? Not all cases that end up examining marriage regulations clearly use the compelling interest standard. A law prohibiting a class of adults from marrying is likely to be invalidated unless the government can demonstrate that the law is narrowly tailored to promote a compelling or overriding or at least important interest. There is no such thing with marriage. There is no basis upon which you can say there's a government interest that would require people from not marrying. So let's think about this. What about two people that have demonstrated that they do not have an understanding intellectually of the responsibilities and of the consequences that attend any marriage? Those that have limited or diminished mental capacities, should they be allowed to marry? How do we draw that line, and where do we draw the line? And when we talk about same-sex marriage, it's a different story, because there we're basing our analysis on something that clearly doesn't have attached to it any real government interest, at least not a primary one. You'd have to sort of stretch, to make that sort of fit. But marriage is one of those things where it's so fundamental that it'd be hard to get around unless there was some government purpose. For example, those that are mentally diminished wanting to get married, the likelihood of them being able to function in such a capacity might go down. And if it goes down, they could become a responsibility of the state, or it could create some other difficulty, right? Let's say they were capable of having children, and they did. Would they be able to take care of those children? So the government can at least fashion, twist together, piece together, maybe under those circumstances, some sort of rationale that the court could accept. So this is not an absolute right, as most rights are not, right? Talk about freedom of speech. You don't get to say whatever you would like to say in whatever venue you would like to say it. So when we get to same-sex marriages, this becomes a more fundamental liberty, right? There's no rationale. There's no real consequence for the government or the democracy in allowing those of the same sex to marry. Everything that a married heterosexual couple can do, a same-sex couple can do, in terms of all the things that are required for them to be functioning members of a democracy that advances the cause of democracy, does not hinder it or hurt it. That would be then, where the government would step in and say, this is problematic. There is no such basis for this. Same-sex marriages carry with them every aspect of a heterosexual coupling. You can have children, take care of those children, functioning members of society, advance the causes of freedom, right? There's not a single aspect of this that's problematic on any level that affects anyone. So requiring every state to issue marriage licenses to two people of the same sex and recognize same-sex marriages validly performed elsewhere, right? The court did not expressly hold that same-sex marriage is a fundamental right, nor did it address the standard of review, right, which would be strict scrutiny. And this is Obergefell versus Hodges. This goes back to 2015. So it's not so long ago. And the case is interesting, if for no other reason, the court is now beginning to wrestle with this idea that they've not had to really wrestle with before. So it's still an ongoing, although I think it has found its way into some sort of subterranean sort of social structure where we're trying to sort of wrestle with the idea. And as things have gotten more complicated in terms of marriage between same-sex couples, we're dealing with a host of other issues around gender. And fundamentally, the marriage thing or issues, concerns are based really on gender. And so consequently, we have to consider those things to be attendant issues of such an important nature that unless we can resolve those, which doesn't seem like we're capable of doing in any real legal way, then we're going to have some issues. What about fundamental right for prisoners, special test in prisoners' rights cases that have come up? So, for example, a statute regulation that restricts the constitutional rights of prison inmates will be upheld as long as the statute or regulation, and this is a quote, is reasonably related to a legitimate, right, peniological interest. In other words, again, the government's got to have an interest here. In this case, it's got to be an interest tied to the penal code, the structure of why people are in prison. In other words, if we give them a right that counters the rationale for having prisons or imprisoning people, then we're sort of undermining the entire structure. So the government has to step forward and say, look, there's a reason why they don't have this right. And if we give them this right, it's going to be problematic in terms of a functioning penal system. And so there is automatically, because the only people that can imprison you, the government, there is automatically a state interest in doing that or in controlling that or having some say in it. So there's a case where you'd be hard pressed to say that every right that a person that's not been incarcerated has, transfer also under equal protection to those that are in prison. That's not, that's clearly runs afoul of, the state interest, right? What about things like procreation? Do individuals have a fundamental right to reproduce that cannot be limited by the state? And in Skinner versus Oklahoma, we have an invalidating a mandatory sterilization program as unconstitutional, right? So procreation, right, is a fundamental right. Again, what about, could there be any exceptions? There's always exceptions to rights, okay? But what kind of exception could there be to the right to procreate? Again, it could go back to the ability to take care of children, perhaps passing on some disease that, automatically limits the viability of a child. It becomes very complicated because in many ways, medically, we don't really understand the consequences of various problems related to people having children. So again, we really can't expect the court to divine answers to those things that have elements that are yet so unsettled or so varied and so vast that the court really can't find a way to either bring it down, the issue at hand, to something very narrow that it can deal with without either bleeding into other areas, which puts the court in the same position, or in a matter of just the structure of the society, having anyone be allowed to procreate could become a major problem because of things like age. At what age can someone procreate? Now, we know there's a fundamental right to do that, but there are limitations based on state interest. When you have minors doing it, two things. If you get minors, and let's just say that's 16, just because we're trying to clear with that number different states and how they define who is a minor for various purposes. But if you're a minor, can you be employed? Can you support a family? Both members, right? Are you capable of taking care of a child emotionally? We know the frontal lobe doesn't, the reasoning part of our brains doesn't really develop until around the age of 24. That's not a set rule. It doesn't mean you can't be a 16-year-old and be able to, think very rationally and fully weigh things and the like. But the likelihood goes down. And if the likelihood goes down, then the government may have an interest, because who's going to support the child? Will the child grow up in an emotionally supportive environment, or will that child not grow up in an emotionally supportive environment? What about schooling for that child? Or if that child turns out to have a serious, illness of some sort, are people that are very young capable of dealing with that? So it becomes a very difficult issue. Again, the court likes narrowly discernible issues that they can address and help resolve, or at least make a determination about whether or not the government really has any interest at all in being involved in the issue. What about the use of contraceptives? Can a state prohibit distribution of non-medical contraceptives? Non-medical is key here. To adults, except a licensed pharmacist, nor prohibit sales of such contraceptions to persons under 16 who do not have approval of licensed physicians. This is Carey versus Population Services International. Look, using contraceptives. Again, you'll notice that they come up with the age of 16. It's somewhat arbitrary, right? But it's reasonable. Person that's 16 should have a reasonable amount of education, so they understand a lot more than someone that may not have gone completely through school or hasn't had much education, someone in fifth grade. So there we have is with the age a determination by society that okay, when you're 16, you may have the wherewithal to make certain decisions, including the decision not to have a child, the decision to engage in sexual intercourse without the concern about there being an unwanted pregnancy. So 16 and younger folks become the issue here that we really sort of focus on in terms of prohibiting the distribution of non-medical contraceptives. What they mean by that is medical contraceptives are those things which might have a secondary or tertiary value to someone that has some sort of physical ailment, as an example, not the only example. And so they would be prescribed something. So the question here isn't so much that. That's a doctor's decision. It comes down to non-medical contraceptives to adults, except through licensed pharmacists. So can you just go, over the counter and have access to these? So the court says, look, use of contraceptives, you can't prohibit the sales of such contraceptives to persons under the age of 16 who do not have approval of a licensed physician. You don't need it. You don't need it. Now, this is based on a couple realities. One, we're not going to stop young adults from having sexual intercourse, and the likelihood without contraceptives that they may give birth, may carry the child to full term and give birth. And now who's responsible? Remember, for the well-being of that child. If these people, the two 16-year-olds, are not committed to each other and the like, it's just something that happens. It creates a burden on society and also great risk for the unborn child. So contraception would seem to be prudent, a prudent step, regardless of social norms or mores that we feel are important. Oftentimes when we get into ethical issues, moral issues, it becomes very cloudy. Even though those that hold certain issues or certain positions on certain issues would say, no, this is the way it should be. There's always exceptions, and we can't mandate what people should or should not be able to do in terms of reproduction. So it becomes a difficult question socially, but a very clear question legally, because there are practical implications that cannot be ignored, and that means they have to be addressed. So the idea here is that allowing young adults access to non-medical, contraceptives, non-prescription contraceptives, and limiting it or allowing it to be rather an over-the-counter rather than pharmacy-driven decision would make the most sense. Of course, a number of things lead to our concerns around abortion, but this is also one of them, right? Unwanted pregnancies by the young, and what if anything can be done with that? Abortion now becomes a very, very complicated issue. Although people feel on one side or the other, it's not complicated at all. But if we just, for a second, only look at abortion from a fundamental rights position, it helps clarify certain things. In other words, there are certain issues that, if we look at them from the vista of point A as opposed to point B, we come to very different conclusions. The issue for the courts, the issue under law really, is what are the governing principles in terms of how the court should look at such cases. And it's so complicated because you're dealing with a couple of issues here that really people feel very strongly about. when does life begin? And there's always been a lot of discussion around when life begins. Fetal heartbeat at the moment of conception, third month, first trimester, second trimester, third trimester, outside the mother's womb. At what point does the state have a vested interest in terms of protecting all of its citizens in protecting a new possibility of life? In other words, at what point does that unborn child become a citizen of the United States, and therefore, sounds odd to even say it that way, but a citizen of the United States, and therefore the government has a compelling interest or an interest in protecting that life. So we really can't decide. The court has tried to, and I think to all of our disadvantage, to make a decision about where that really begins. And when an abortion should be acceptable or not. On one side, you have those that say an abortion is an absolute right, it's a woman's right to choose, and that nothing should get in the way of that. On the other side of that, the other end of that spectrum, you have people that say no. There has been a decision here to engage in an activity that could lead to pregnancy, and therefore there is a responsibility to protect that life as soon as that happens. What's interesting here is if you contrast the right to procreate, then we say you have a right to procreate. So does that mean that you would have a right not to procreate? Because that comes down to contraceptives and this idea of abortion. You decide, don't want to have a child. So we have a right to procreate, but does that imply also we have a right to decide not to procreate? And I don't mean only through abstinence, saying I'm not going to parent a child. Okay, you could decide that you don't want to procreate, not based only on that decision, but that things will happen that are unintended consequences of sexual relations, and that if we are allowed to use contraceptives and we are allowed to procreate, it would follow logically that we should be able to abort. Now, the abortion issue has been focused and centered on a woman's decision, which makes sense. It's a woman's body. They have to carry the full term if they're going to give birth. And along the way, there are any number of things that can arise that are problematic. For example, some sort of medical condition where the child might be born with some sort of mental or physical issue. Parents or prospective parents have to make the decision. Is that something? And again, I want to get away from those extremes, okay? Because on the one position is it doesn't matter if the child has an infirmity of some sort or might be born with something. You don't get to choose. You've become pregnant, and regardless of what that child is going to have to deal with once born, that is no longer a decision that you should be making. Well, seeing how you're probably parents, and let's assume for a second that they want to have a child here under these circumstances. One would assume that they're the ones that are going to have to bear the cost emotionally, psychologically, financially of that of carrying that child or fetus to full term, and nobody else. Now, the state could say we have an interest because the cost factors might be so high that we're going to have to step in and supply all kinds of medical support. It's one of those arguments that really are far-reaching. That it kind of moves into a lot of other areas. Most notably, when should a government step in? We as a collective of that government step in and provide assistance of some sort to folks. I mean, where does that happen? How does that happen? It becomes really complicated because it's difficult to divine where that line is of government intervention and where government just steps back. So the issues of procreation, contraception, and abortion are tied together. It's difficult to make a decision in one of those areas and to completely not consider it in the light of others. So the court, wrestled with this idea of how you're going to go about making these decisions, and in my view, try to skirt the issue. What I mean by that, not deal with it. I can't say directly, but not deal with it in a way that seemed to make a clear distinction between a woman's right to choose or not. They kind of walked a line that has made it difficult and has kept the argument going. Now, politically, it's something that people feel very strongly about, and there's some oddity around that, because when you ask people an oddity about the position, if you ask people, do women have a right to choose, that number is very high. There seems to be general agreement within the public that a woman has that right, an absolute right. We'll hold off on absolute for a second. And then the same public, when asked if they would make that choice for themselves, overwhelmingly also say no. So we recognize, the public does, that there is this right, but it's not one that most people would necessarily want to exercise. They would like to avoid making that, being put in that position, because they apparently don't want to have to make that difficult decision. Whereas with procreation, use of contraception, for the most part, people are also in line with that. The right to procreate and the right to use contraceptives. It gets a little more difficult when we talk about the young. At what point, with abortion, especially, should someone who becomes pregnant be allowed to make that decision without parental involvement? Someone that's still, under the control, for lack of a better word, of their parents support, and a parent's, responsibility for the sort of process by which that child is going to experience their life. Parents have parental responsibilities. They can be held legally responsible, for not providing some of those, right? And so, on the one hand, parents are required to do certain things. On the other hand, the decision has to be made about whether or not those parents should be involved in the decision about their child having an abortion. And so it becomes another one of those very complicated issues, because not only are there strong feelings on every side, not only does it involve fundamental rights and defining what those are, and where there are limitations on those rights. All rights have limitations, as we said. So we're really trying to answer a very complicated question. Now, there are those on one side, on both sides actually, that say this is not complicated at all. Woman has an absolute right, we're done. On the other side, no, it's a moment of conception. That's a life. It's a potential life, and it needs to be protected, and no, an abortion should not be permissible, especially in the light of the capacity to use contraceptives. Now, a quick aside, we all know contraceptives are not 100%. Even if we take the passion of the moment argument out, which is, listen, people may want to use birth control, but there's a certain element of passion that ultimately means people are not thinking rationally. Despite, measures to not become pregnant, it could happen. Failure of contraceptives, of course, or just this passion of the moment argument. So it's not as if you can say, well, they didn't protect themselves. On the one hand, it was a failure of a contraceptive, and the other, it was a failure of the ability to control oneself. And I don't think the whole point of passion that happens between people is that they can control that. I mean, the idea of passion is that it happens. It happens in the moment. And so how do you deal with that? Take those things and put them aside. I hope you're getting a sense that we have to keep putting things aside, things we really can't deal with, we can't resolve the answer to. It gets, or arrive at an answer to. So then we make the mistake, I think, in terms of getting our legal minds around it, the fundamental rights of all this. Pregnancy isn't a singular experience. In other words, not everyone experiences. Forget the conditions we've talked about, whether they wanted to or not. Not everyone experiences the same process. It's not like you get pregnant, everything runs smoothly, you give birth, child is healthy, and once you become pregnant, somehow you automatically want the child. None of that. So what happens is we begin to try and break it down. We begin to try and say, okay, can we separate? And this is very much the way the court operates. Can we separate a specific piece of this? And can we move it aside? And can we somehow, I don't want to use the word skirt, because that's not exactly what it is. Can we somehow isolate this one particular situation from other situations and say we can resolve this one? It's become very difficult because at the end of the day, you can't make some of those decisions. You can't divine those things, and as a consequence, there's a fundamental failure to really resolve them. So when we talk about the court, and there are several cases that you'll be responsible for, and there'll be a list of all those cases in the review lecture that will take place. So we're stuck with divine. So here's a few of those things, of the issues that we've touched on, and now I want to kind of explore them a little bit more. The pre-viability. In other words, does it place an undue burden before liability, right? A realistic possibility of maintaining the fetus's life outside the womb. That's what we mean by viability. So the period before that, where if you take the child and bring the child outside the womb, the child can't sustain itself. I'm using the word child because, it could be fetus, it could be unborn, but basically, let's give it the title child. Now, there's a lot of people that disagree with that, that particular use, the nomenclature there. But that's you'll see in a bit why I want to use that term. Okay, we'll keep with that term. So if you can have, in this case, the fetus, right, sustain itself outside the mother's body, then is it really a life or not? The health and the life of the fetus only if the regulation does not impose an undue burden or substantial obstacle to the woman's right to have an abortion. Think about that. Again, it's an undue burden on a woman's right to have an abortion. That seems to be a pretty clear statement by the court. This is in Planned Parenthood of the Southern Pennsylvania versus Casey. In the Casey case, in Casey, the court is looking at this issue, right? And again, here the court has not specifically defined, what will constitute an undue burden, stating that a state can adopt a statute designed to persuade a woman, and the other key word is persuade, a woman to choose childbirth over abortion as long as the statute is reasonably related, again here, right, to that purpose and does not put a substantial obstacle to abortion in the woman's path. So the court has recognized that women do have this choice. Remember, government-supported abortion is a different thing, political consequences. Government can't restrict it, but the government doesn't have to support it. A statute will not impose a substantial obstacle or an undue burden simply because it has the incidental effect of making it more difficult or more expensive to obtain an abortion. The more expensive issue is around whether government should pay for abortions or government-funded abortions or not. Then we get to the issue of informed consent. Is there no undue burden there? Yes. States can require abortions to be performed by licensed physicians, and it is not an undue burden to require the physician to provide the woman with truthful information about the nature of the abortion procedure, the health risks of abortion and childbirth, and the probable gestational age of the fetus, right? It's not an undue burden for people to get information and for them to understand what the consequences might be of making a decision to carry full term or to abort. What about a waiting period? A waiting period is also no undue burden, requiring a 24-hour waiting period between the time the woman gives her consent or makes that decision. and goes ahead, has informed consent, and the time of the abortion does not amount to an undue burden. In other words, what we're saying here, in Casey, is look, taking a moment after getting all this information to decide that no, you're going to move forward or you're not. That time frame does not seem to be or create an undue burden. Now, we're moving aside the fact that this might be have some sort of detrimental effect or medical impact on the woman. Maybe those 24 hours become significant, but that's not what we're talking about here. Right? We're talking about, being able to make that decision and take a moment to reflect on it before moving forward. What about parental consent? No undue burden. A state may require a minor to obtain her parents, one or both, consent to have an abortion or give notice to them, even if their consent is not required. If there is a quote-unquote bypass procedure, open quote, that's the statement, that's how we refer to it, whereby the minor may obtain an abortion without notice to or consent of her parents with the consent of a judge. The judge is required to make a prompt decision as to, first, whether the minor is sufficiently mature to make her own abortion decision. So you got a judge determining the reasoning ability of the person before them and whether or not they should be allowed to make that decision. Second, is she not sufficiently mature, whether having an abortion without notice to her parents, is it in her best interest to do that? Hodgin versus Minnesota, Ohio versus Akron. There's several cases, and they continue on. It's been 30 years since Hodgson. What about, and this becomes, I think, even dicier, because now we're talking about adults making a decision. What about spousal consent? Is an undue burden. Parental consent may not present an undue burden, may not, but what about spousal consent, right? The spousal consent is it an undue burden, right? It is an undue burden to require a woman to sign a statement that she has notified her spouse that she is about to undergo an abortion. Planned Parenthood of Southern Pennsylvania, again, the Casey case. Why is it an undue burden? There's any number of realities that couples face where informing their spouse might create so much unrest in the relationship that it's counterproductive to some sort of state interest, stability in marriage, and all that might extend from that. But also, a spouse, the woman may say, I have enough children. I don't want any more. Or I no longer want to be in a relationship with this person. We're married, we're in the process of getting a divorce, or I don't want to be married to this person any longer. And now the consequence is that they're carrying a child forward. So there's, it is an undue burden on lots of levels, emotionally, psychologically, financially. So many things. If a woman becomes pregnant, let's say from another man during her marriage, it's an indiscretion. Let's say it's an affair. It really restricts women. It's their right to make a decision about their body. That's pretty clear, right? Spousal consent becomes problematic. Now, one school of thought is, well, that person has a right to know because that person is the father of that fetus, if you will. And here we'll call it a child because that's how it's really being looked at, whether or not to have that child in a case like this. So I think it's a little bit clearer to think of it that way. A lot of people disagree with that, but I think really it's having the child and not having the child rather than just, whether or not you want to terminate the pregnancy, when we're talking about just a fetus. So that's an undue burden, and courts decide so. What about physician-only requirement? That physicians are the ones that can perform abortions. They have to be licensed. That does not impose an undue burden. We want to protect the woman here. We don't want anyone performing abortions. And in fact, there used to be sort of back alley abortions, backroom abortions. Many women died. They weren't done properly, and it put a woman's life in jeopardy. So we want people that understand the process procedure, have been trained to do it, and we want them to do it. And so, it's not an undue burden to say that physicians are the ones required. That doesn't create an undue burden, as does a spousal consent. So, so if you think in terms of protecting a woman, and by the way, the society, the government has a vested interest in protecting its citizens. So just like you have to have medical licenses in order to practice medicine, we do that licensing process to really minimize the risk that people, don't suffer medical consequences. We have medical insurance, malpractice. All of this is designed to protect the patient and the doctor as well. Doctors make mistakes; they're not intended. And who would want to practice medicine if they were so vulnerable to economic, consequences for errors? Not that we want errors, but they happen. That creates a problem for us as a society. We need doctors. They need to be protected in some measure. They also need to be held accountable, right? So fundamentally here, requiring physicians only to do it makes the most sense. It eliminates illegal activity. That's why, eliminating abortions or making them illegal is not going to solve anything. It may make those that feel a woman doesn't have that right and that she must bring the fetus to full term is problematic, because a woman that doesn't want that is going to seek out a way, either through illegal means, in terms of someone that's not licensed. If the doctor doesn't want to lose their license to perform it, the abortion, a woman wants to terminate the pregnancy, we're back to back alleys again, and forcing women to make untenable choices about their own health. So here again, we have to make a decision to protect women, and to take away the right just puts them in greater jeopardy. There's no benefit to society in doing that. Again, as soon as we bring in any religious set of beliefs or moral beliefs about this becomes a very cloudy issue legally. The court does not resolve, ultimately, moral issues. That's not the point. They're not there to be the arbiters of morality. They're there as the arbiters of the law. And so they have to look at this from a legal position. Now, it's not to say that there aren't some undercurrents of morality in almost everything, right? But the court, while it may nod its head to it and may see a consequence of that, good or bad, it doesn't make decisions or shouldn't make decisions based on that alone, especially. All right, so we get to a really complicated, one other thing about physicians, admitting physicians. They have to be, they have to perform abortions because they have admitting, rights at a nearby hospital. That doesn't impose an undue burden. All the things that don't pose an undue burden really are there to protect a woman's right. Spousal consent is an undue burden, again, to protect a woman's well-being. Okay, now we get to the more complicated issue, and they're all complicated, but this is more so, because it really stirs up a lot of moral issues for the public in general, which creates them for politicians who would like to not be caught on the wrong side of an issue in terms of being reelected. That's not to say they don't have strong, real feelings here or points of view. It's not to say they are vacant lots of, morality as a collective group. They're not. But nevertheless, their job is to listen to their constituents, and so that means they've got to make some decision about where they stand on these issues. So partial birth abortion, a ban, is no undue burden, right? And this goes back to 2016 in Whole Woman's Health versus Hellerstedt, right? It goes back to Gonzalez Carr. All right, so partial birth abortions, a federal law, which was the Partial Birth Abortion Act of 2003, prohibited intact D&E, a type of abortion procedure, most of us are aware of that, is partially delivered, killed, and then the fetus is partially delivered. They use the word killed here, and then fully removed from the woman's body. It does not on its face impose an undue burden where other abortion procedures are available. Again, the language here is very important. So I want to state that again. The Partial Birth Abortion Act of 2000, prohibiting intact D&E, a type of abortion procedure in which a live fetus is partially delivered, killed, and then fully removed from the woman's body, does not on its face, does not automatically and obviously and without any further consideration, does not on its face impose an undue burden when other abortion procedures are available. Okay, so what's the line here? The line is that saying you can't do this kind of abortion does not create an undue burden on a woman's right, because there are other ways in which she could abort the fetus. So on its face, it doesn't involve that. It's not clearly at that moment. It's not enough. So it seems pretty rational. It's a controversial type of abortion. It creates other issues that are pragmatic in nature and have to be dealt with, and that complicates matters. So the courts, I believe, sidesteps the issue, which is, look, you've got, on its face, you can write a law like this. It's an undue burden because a woman has other ways of doing this. So again, it skirts the issue of whether a woman has an absolute right, because now there's this other facet to it. There's this other face to it, right? Which is the way in which that abortion or the nature of the abortion is carried out, right? So it's not so much a woman's right to or not to, it's whether a woman has a right to do it this way when there are other ways of doing it. Now, choice of ways in which to do it seems to be some sort of moral decision. There's some element of that here, because an abortion is an abortion. And if the unborn child does not have rights protected by law, does it really matter if there's a partial birth? I mean, this gets really complicated. Does it matter? Does it have a consequence? Does it change anything, or does it just address what others might find, more difficult? All right. So the law includes specific anatomical standards and an exception to protect a woman's life. So that's a relatively straightforward decision, right? You've got to protect a woman's life. You have to do it this way. So medically, there's a reason for it. So, okay, let's put that aside, because we would all agree, I think, that if there's a medical reason, and some don't, so I shouldn't say all, that a mother's life is endangered, then the process by which the abortion takes place is of little or no concern. Now, there's uncertainty within the medical profession whether banning the intact D&E procedure creates a significant health risk for women. That doing the process actually creates the health risk. Now, think about the complication there. Woman has a right to choose, and let's say medically she needs to do it because she has to protect herself. But the procedure itself creates problems, medical problems, or could create medical problems for the woman. So if a woman has, the partial birth abortion, if there is another way to do it, D&E, if that creates more of a health risk for the woman, how do we weigh those two things, right? So although the court generally upheld the statute, also held that the statute could not be applied in situations wherein the woman's health would be endangered. Gonzalez-Card, that's pretty straightforward. Which invalidated a state partial birth abortion ban that did not contain clearly defined anatomical standards nor provide any health exception. So the court decides on very narrow legal terms that, okay, look, you're going to have to contain clear language about how this is defined. What makes it a partial birth abortion, what does not. There are other regulations around abortion. As you can see, when we talk about fundamental rights, we talk about equal protection. There are, it's very complicated. What about, now we get into real, murky waters in terms of legally getting our minds around this constitutionally and the like. What about the post-viability rule, right? May prohibit abortion unless a woman's health is threatened. Okay, so once the fetus has become viable, it can live outside the mother's body. All right, the state's interest in the fetus's life can override the woman's right to choose an abortion, but it does not override the state's interest in the woman's health. Okay, once the fetus has become viable, that's what we're talking about now, it can live outside the body of the mother, obviously with medical assistance. The state's interest in the fetus's life can override the woman's right to choose an abortion. So now we've got a situation where viability steps in. And now, which juxtapose that against partial birth abortions. The viability issue is there, but the issue is addressed on different grounds. So it doesn't violate the state's rights interest in a woman's health. So a woman, the right in a woman's health could negate the viability issue, right? Thus, after viability, the state can prohibit a woman from obtaining an abortion unless an abortion is necessary to protect the mother's life or health. However, viability is itself a medical question. All right, they bounce it over to, whether or not, doctors should be making this decision. And a state cannot unduly interfere with the attending physician's judgment as to the reasonable likelihood that the fetus can survive outside the womb. This is Colati versus Franklin. Here's what's so interesting about this. The court in its own way is very consistent on this. And that is that there is this right for a woman to make the choice. And one of the reasons is, for the health and well-being of the mother. That line of reasoning rests squarely in every single issue that's attendant to the abortion question, as well it should. Also, medical judgment. Can the state really say, no, this is when viability happens, or that the mother's life is not endangered? So we leave that to the medical professionals. But then there are sort of these other considerations or other voices that say, well, really, that could be done with, really the decision on the doctor's part based upon what the mother wants. And so really the issue of whether or not viability or the mother's health may not come into question at all, but is brought up as a means to make a decision that would not otherwise be made. That would not be the decision medically. We have no way of knowing that. And at some point you have to trust that, people do what makes the most sense and is, for themselves. So the post-viability rule can prohibit abortions unless a woman's health is threatened. So when a court is faced with a statute restricting access to abortions that may be applied in an unconstitutional manner so as to harm the mother's health, it should not invalidate the statute in its entirety if the statute has valid applications. Just because you have a case that where the statute is problematic does not mean that the statute has no weight moving forward. So an example, a court should not have invalidated an entire statute requiring minors to give parents notice before obtaining an abortion merely because the statute did not include an exception for cases where the minor's health is at stake. Rather, it should be declared invalid to the extent that it reaches too far, but otherwise left intact. Overreach. In other words, not specific enough. We've talked about this. Court doesn't like that. Court does not like statutes written in a way that go well beyond what the state interest might otherwise be. Financing abortions, as I've said, is a different issue here. Federal nor local governments are required to grant medical benefit payments for abortions to indigent women, even if they grant benefits to indigent women for childbirth services. So an indigent woman can get services, right? Childhood services, but doesn't get, is entitled to monies for an abortion. Once the child's here, yes, but not in the process of abortion. It becomes problematic, to say the least. So that's Mather versus Ray, and that goes back to 1977. With all the things that are going on in the country today, who knows how these are going to change and what impact they're going to have. Also, Webster versus Reproductive Health Services. All right, now we move away from abortion onto other things that are so cloudy that the court really doesn't make decisions based on them. and so we skirt. The one is obscene reading material. The right of privacy encompasses the freedom to read obscene material in your home, except for child pornography. We've made a decision that this is one of those moral things, and there are other issues attendant here, that children should not be in any way involved in what we would call obscene sexual matter, either in viewing it or having them participate in it, that they are a protected class, and that is not permissible. All right, so reading obscene material, Stanley versus Georgia, Osborne versus Ohio, but it does not include the right, again, it does not, however, include the right to sell, purchase, receive, or transport obscene material. This is the Paris adult theater case in 1973. So it's a bizarre set of circumstances. We understand the child, limitation on it. I think we can all agree to that. I don't think that's, as a society, anyone is comfortable with that. But they said it's okay in the privacy of your own home to view these materials. But the transporting of them or getting them to someone that wants to view them, that's illegal. Of course, now with the internet and accessibility, it's impossible to control. And so the easy way out is for most of these places that provide these materials to say that they're there for, as the court required, educational purposes. So we've skirted the issue. Even defining what obscene is becomes impractical. Keeping the extended family together is another issue. The right of privacy includes the right of family members, even extended ones, to live together. Doesn't seem like much of an issue, right? So it's very practical. Zoning issues come in here, or ordinances. They can't prohibit extended families from living in a single household. And again, this is economic in nature too. This is more versus the city of East Cleveland. That, look, you may say that only 4 people can, live in a particular dwelling. Maybe there's 8, but if they're family or extended family, you shouldn't interfere with that. We're not in the business of conducting, family, what are the family rights, what are not family rights, and so maybe that's the only place they could live. And so now you're saying no, families are faced with, under statute, the requirement to limit that, and that's really problematic. Rights of parents, which is another area. Parents have fundamental right to make decisions concerning the care, custody, and control of their children. Troxel versus Granville, and this is 2000. And really it comes down to 2 things, education and visitation. Although the state education may prescribe reasonable educational standards, it may not require that all children be educated in public schools. Pierce versus Society of Sisters of the Holy Names of Jesus and Mary is one case. Fundamentally, look, you don't have to send your kids to public school. You have a choice to educate your children the way you'd like. Maybe a religious school because you believe in those principles. Also, visitation is another area of rights of parents. A state law is found to be overbroad and in violation of parents' rights, where it, 1, authorized the courts to grant any person, including grandparents, the right to visit a child upon finding that this would be in the child's best interest, and 2, did not allow the judge to give significant weight to the parent's offer of meaningful visitation opportunity and the traditional presumption that a fit parent will act in the child's best interest. Troxel Granville again. So it's overbroad, the law. It doesn't mean that there aren't elements of it that make sense. It's just that it goes too far. You need to, the courts want to see statutes written, laws written that are narrowly tailored. 2 reasons. Court can deal with those, right, in terms of examining the constitutional impact, and also in terms of narrow, it separates an issue from a lot of other complicated issues and doesn't have to worry about the statute reaching groups of people that it was not intended to reach, which further complicates matters. The courts like focused, narrow matters to consider. We talked about previously standing and all of that. The court wants to know specifically what they're dealing with. All right, what about intimate sexual contact? The state has no legitimate interest in making it a crime for fully consenting adults to engage in private, intimate sexual conduct that is not commercial in nature. In other words, you're not filming it and putting it out there. Even that has changed. This idea, sex does not work itself out legally, other than underage or child pornography. The rest of it is sort of, look, so long as it's not clearly hurting anyone, there's consent, the court's not going to go around, and nor should the state, trying to control it. All right, this next one is really a problem these days. It's the freedom from collection and distribution of personal data. The right of privacy does not prevent the state from accumulating and computerizing the names and addresses of patients for whom dangerous drugs are prescribed. Right, that's when you go get a drug at a drugstore and you have to sign your name. They look at your license. All this goes back quite some time, and the state can republish the recording of an official act, such as an arrest. Privacy from what states can do is pretty important. For example, if you're a child sex offender, you go on the offenders list. It's a published list. Where you live, you can punch in your address, and up will pop all the names and the addresses of those people who have been convicted of this sort of conduct. And for them, even if they've served prison time, this decision follows them indefinitely. Restrictions on the right to vote, residency requirements, right? There could be relatively short residency requirements. So you don't want someone moving to a state, for example, and saying the state has a statute saying you have to be here for 10 years before you can vote. That's just problematic. Voting is fundamental. One would argue the most fundamental of all rights. So restricting the right to vote based on residency requirements, is another issue. Property ownership and poll taxes, I think people are pretty clear about. I don't feel we need to really go through that. And primary elections, we're dealing with that right now. I want to go into voting and political gerrymandering and all of that, but only tangentially. So we move more into the the First Amendment and freedom of speech and that sort of thing. Again, I'd like to remind you that the cases that you need to know and prepare for the midterm will be laid out for you. You'll get those in an email or and an announcement. You should check the website, and Blackboard. And we will move forward, finishing up this section in Lecture 3 on equal protection, and then moving in. And that's all the material that will be covered on the midterm, everything up to the end of equal protection. And then the final will really focus on freedom of speech, pretty much on its own. And because it's all related in some measure, though we will revisit some of these issues, which would be necessary in order to really fully explore free speech and that sort of thing. Okay, so that's where it stands. This is the second lecture. The third lecture will be up for you to review as of next Tuesday.